Hello viewers, today we are going to do the debentures which are another portion of the capital management. These debentures are issued by the company to avail the funds for the company. Now this is the part 1C of our capital management portion of company law unit 5. Let us try to know what is the meaning of debentures. The debenture is a name which is applied to certain types of documents evidencing an indebtedness which is normally but not necessarily secured by a charge over property. This definition has been given by Gower LCB. Now, the meaning of this definition is that debenture is a certain type of document which is given after the funds have been supplied by the debenture holders. Now, for providing such funds, the debentures could be secure or they could be without a security. So, having a secure debenture is not a necessity, but usually a security is provided. Debentures are also bonds which are issued in return of borrowed fund, and debentures are generally secured upon the company's property or undertaking. So, whatever property the company is having, it is given as a security in a ratio of how many debentures are issued, and they are broken down into number of these debenture units and given individually to the debenture holders. Now, let us discuss what could be the terms of issue of debentures. A very important term which is usually taken for debentures is the pari passu clause. Pari passu clause means with equal ranking. Now, this term pari passu means ranking equally amongst themselves. That is, no matter what could be the time period in which the debentures were issued, whether earlier or later on, if the pari passu clause has been included in the terms of their issue and has been mentioned in the prospectus, then they shall be ranking equally. So, every holder of debentures issued with pari passu clause shall be entitled to share the proceeds of the security realized, even though these debentures were issued at different points of time. Say for example, 100 debentures of rupees 100 each have been issued by the company. That means 10,000 debentures, amount of 10,000 debentures have been issued in the first instance, and in the second instance another 100 debentures of rupees 100 each have been issued. Now, if there is a pari passu clause which has been included with the first series of debentures, then the second series of debentures having the same security shall rank equally with the earlier debentures. So, if there is a failure to repay the debentures, then that security which is to be realized will be divided and paid to both the series of debentures in an equalized manner. Now, what happens when the pari passu clause is not included in the debentures issue? The debentures shall rank according to the dates of issue of debentures, that is, a debenture issued first shall have a priority over the debentures issued afterwards. If some debentures are issued on the same date, then the priority shall be determined according to the serial number of the debentures issued. Let us know about this in taking the example which we had discussed earlier. Now, supposing series A has been issued 100 rupees debenture and 100 such debentures have been issued in the first instance, that is the first series, and in the second series we have with the same security we have another set of 100 debentures with rupees 100. So, 10,000 debentures issued first and 10,000 debentures issued in the second series. Now, if the pari passu clause is not there included in the first issue, then the second set of issue of debentures shall not rank equally. So, priority shall be given to the first series of debentures. Hence, if the company has faltered or it is not able to repay the debentures, then the security shall be realized and the amount of the debentures of first series shall be paid out first, and whatever remains shall be paid out to the second series of debentures. Now, what happens when all the debentures, both the series, have been issued on the same date, but different sets of debentures are issued? In such a case, the ranking shall be known by the serial number appearing on the debentures, because debentures are like shares which are marked from 1 to the number of shares issued. Hence, even the debentures which are marked from series 1, 2, 3, 4 and so on, the one which has the first number shall be having a preference over the later on. Now, there could be some restrictions on the powers of the company. A company is not entitled to issue a new series of debentures which have priority over an earlier series of debentures, or they are ranking pari passu with an earlier series of debentures, unless such right is expressly reserved under the terms and conditions of earlier series of debentures, which means that whenever we are issuing the first set of debentures or first series of debentures, the pari passu clause has to be included therein and thereat. We cannot rank the later on issued debentures to rank equally among the earlier debentures, which means the pari passu clause has no utility if it is included in the later series of debentures issued. It has to be included in the earlier series of debentures. If this has not been done, then there is a restriction on the power of the company to have a priority of the later on issued debentures to rank equally with the earlier debentures. Now, we will be discussing section 117, which includes some special provision as to the debentures. No company shall issue any debentures carrying any voting rights. It may be recalled that only the shareholders, that is equity shareholders, have a right to vote. The preference shareholders have a right to vote only for their dividend being in arrears for the specified period of time. Hence, debentures can never have any kind of voting rights either to their interest or any other form of profit being available to them. Whenever the debentures are issued, the debenture trust deed is also created after the debentures have been given to the debenture holders. Now, this debenture trust deed is discussed under section 117A, which is an agreement between the debenture holders and the company. It includes all the terms of payment, the security offered, the amount which shall be paid by way of interest, the amount of security and many other clauses, so that the debentures are fairly well secured. Now, let us discuss these terms once again. The form of the debenture trust deed shall be in such form which can be prescribed by the central government. The time period for the execution of trust deed shall be executed within such period as may be prescribed by the central government. Regarding the inspection and copies of the trust deed, it can be done either by the members of the company or by the debenture holders themselves. Now, we will discuss about the debenture trustee. There is a mandatory appointment of the debenture trustee whenever the debentures are issued over a security and the public company issues the debentures. If the company issues a prospectus to the public for subscription of its debentures, Then the company shall appoint the debenture trustee or a set of trustees. The debenture trustees shall be appointed before the issue of prospectus. So, the correct procedure is to enter into an agreement with the debenture trustees. After having reached that agreement, the consent of the debenture trustees is taken and their name is included in the prospectus. This prospectus is then issued to the public, and the public, after reading the prospectus, can subscribe to the debentures. After the debenture applications have been received by the company then carries on a procedure to allot the debentures. And when the debentures have been allotted, the debenture trust deed is also filed with the debenture holders and with the ROC as well. Now, the debenture trust deed includes all the clauses and agreement which were actually appearing in the prospectus. There should not be any kind of inconsistency in the prospectus and the debenture trust deed. And the main work of the debenture trustee is to safeguard the security of the asset for the debenture holders. Now, we will discuss about the debenture trustee's appointment and the consent which has to be given. The debenture trustees shall be appointed before the issue of prospectus. The consent shall be given by the trustee. The person who is proposed to be appointed as debenture trustee must give his or their consent to the company to act as a debenture trustee. Such fact shall be stated on the face of the prospectus. Now, there could be an instance where the debenture trustees suffer from certain disqualifications. So, such persons cannot be appointed as debenture trustees. Let us know what are these disqualifications. A person cannot be appointed as a debenture trustee if he beneficially holds shares in the company, or he is entitled to receive monies from the company, that is, he is a creditor of the company, or he has given any guarantee in respect of repayment of debentures or payment of interest on debentures. Now, all these three clauses actually point out to the fact that the debenture trustee should be an independent person who should not be in any case having interest in the company, whether by payment of any money or receiving any kind of money, or receiving any dividend or interest in the shares even if he holds them beneficially. Now, the functions of the debenture trustees. The debenture trustee shall protect the interest of the debenture holders, creation of securities within the stipulated time, redressal of grievances of debenture holders, taking reasonable steps to remedy any breach of covenants of the trust deed, call a meeting of debenture holders as and when necessary. So, the whole idea and aim of appointing a debenture trustee by the company is to safeguard the interest of the debenture holders. He sees whether the adequate security for the debentures has been created by the company. Such a security is lying secured and has not been disposed of. If the market value of such security has gone considerably down, then whether that security will be able to fetch that much money to repay the debentures. In case any debenture holder has any grievance with regard to the payment which has been received or security has been created, he can root all his grievances from the debenture trustee. Then if all these problems have happened, then the debenture trustee takes reasonable steps to remedy any breach of covenants or clauses which have been included in the debenture trust deed. If necessary, he even calls a meeting of the debenture holders to discuss these problems and to convey the message to the company. The debenture trustee also ensures the following. Number one, that the assets of the company are sufficient to discharge the debentures. Secondly, the prospectus does not contain any matter which is inconsistent with the terms of trust deed. Thirdly, company does not commit any breach of any provisions of the trust deed. So, it is quite a responsibility on the shoulders of debenture trustees to monitor that the security is enough, the company has not parted away with it, and it is enough to discharge the debentures whenever they shall be matured. Even when the time period of repayment has not come and the market value of the security has gone down, then the debenture trustee can ask the company to give more security so that the interest of the debenture holders can be safeguarded. Secondly, he will also see that the prospectus does not contain any clauses or any covenants which are which contain any matter which is inconsistent with the terms of the trust deed. So, there should be consistency which is maintained with the matter published in the prospectus and in the trust deed. Also, the debenture trustee has to see that the company has not breached or committed any breach of any provision of the trust deed. Now, there could be certain instances where the debenture trustee could apply to the company law board for redressal. There could be certain grounds for this application. This can happen when the assets of the company are insufficient or are likely to become insufficient to discharge the principal amount when it becomes due. Now, the power of the CLB in this regard shall be that the CLB may impose such restriction on the incurring of any further liabilities as it thinks fit. Now, these certain restriction would be that the company cannot take issue more debentures or take more loans or give away the security of the company which is likely to affect the interest of the debenture holders. So, certain restrictions in this regard can be imposed on the company by the company law board. Now, we will be discussing section 100C, in which the liability of the company to create security and debenture redemption reserve shall be taken. It is mandatory on the company to create the DRR, which is called as the debenture redemption reserve. A company which issues the debentures shall be creating the DRR, which will have the credits concerning: number 1, the amount, which shall be adequate amount which is credited to the DRR. The sources for the DRR shall be out of profits of the company, and the period in this regard shall be every year until the debentures are redeemed. So, actually the DRR is nothing but an appropriation of profits every year with certain amounts depending upon the repayment period. If the debentures are to be repaid in 3 years, then the total amount of debentures shall be bifurcated or divided into 3 years, and an amount of 1/3 of the total debentures to be redeemed shall be credited to the DRR every year or until the time period that the debentures are repaid. Now, this DRR shall be utilized for the purpose of redemption of debentures only. It cannot be misutilized for any other provision or any other payments. The company shall pay the interest due on debentures and principal amount which is due on the debentures. So, the DRR shall be used for the payment of interest and the principal amount as well. This shall be done in accordance with the terms and conditions of issue of the debentures. We had already discussed the right of the debenture trustee to apply to the CLB. Now, there could be an instance where the debenture holders can themselves apply to the CLB. Now, the grounds of complaint can be: a debenture holder may make a complaint to the CLB that the company has failed to redeem the debentures on the date of maturity. the powers of the CLB in this case shall be that CLB may order the company to redeem the debentures forthwith, and on getting such an order from the CLB, the company shall make all the arrangements to make a repayment of debentures. If it has taken any bank loan for any other purpose, it shall first be utilized for the payment of debentures which are ready for redemption. Now, we will discuss section 118 which is the right to obtain copies of and inspect the trust deed. The nature of rights under section 118 is inspection of the trust deed can be done according to the provisions of section 163. Section 163 allows the inspection of the trust deed and other similar documents by the shareholders, that is members of the company, and debenture holders during the business hours of the company. At least 2 hours shall be provided for such an inspection. Also, they can obtain the copies of the trust deed within 7 days of the demand being made. Now, this right has been given as earlier discussed. Every debenture holder has a right to inspect the copies, and every member also has the right. The orders by the CLB, if the default is made by the company in allowing inspection or forwarding copies, then the CLB may direct the company to forthwith allow inspection or forward the copies. If a person who wants to obtain the copies and a default has been made, then the CLB can order and it can direct the company to allow the inspection or forward the copies. Now, what could be the liability of debenture trustees? Responsibility portion we have already discussed in section 117. Now, this liability can be discussed under section 119. The liability for damages is if the debenture trustee is guilty of breach of trust, or the debenture trustee fails to show the degree of care and diligence expected out of him, and loss is caused to the debenture holder, then the debenture trustee shall be liable for damages. So, all these three conditions should be subsisting for holding a debenture trustee liable for the damages. So, he should be guilty of it, he should have failed to show fair degree of care and diligence, and loss should have been caused to the debenture holders due to his negligence. No exemption or indemnity can be given to the debenture trustee if he has shown negligence under section 119. So, exemption or indemnity cannot be given to a debenture trustee in respect of the liability of 119, and any provision which exempts or indemnifies the debenture trustee from liability shall be void, whether such provision is contained in the debenture trust deed or any contract. So, one cannot make the debenture trustee immune to section 119 by creating a provision either in the debenture trust deed or any contract or under the articles. With this, we are concluding our today's session. In today's session, we had discussed about the debentures. The debenture section started from 117, 118, 119. We had discussed many provisions relating to the issue of debentures, whether the debentures are secured or unsecured, whether the security is adequate or not, the appointment of the debenture trustee under section 117, the disqualification of the debenture trustee under section 119, whether an immunity can be granted to the debenture trustee for the disqualification and failure to look after the interest of the debenture holders. I hope you thoroughly enjoyed this session. Thank you.